A pleasant day to everyone. For this video, we are going to make a comparison of the crimes of adultery and concubinage. We are also going to discuss their similarities and differences because I think there are a lot of misconceptions with respect to these crimes. Not just law students are confused, but some law practitioners as well. So I will attempt in my own capacity to discuss to you each and every element of these crimes. These are the provisions of the crimes of adultery and concubinage. For the crime of adultery, we have Article 333. Who are guilty of adultery? Adultery is committed by any married woman who shall have sexual intercourse with a man not her husband, and by the man who has carnal knowledge of her, knowing her to be married, even if the marriage be subsequently declared void. Second paragraph, adultery shall be punished by prisión correccional in its medium and maximum periods. Third paragraph, if the person guilty of adultery committed this offense while being abandoned without justification by the offended spouse, the penalty next lower in degree than that provided in the next preceding paragraph shall be imposed. For the crime of concubinage, this is the provision. Article 334, concubinage. Any husband who shall keep a mistress in the conjugal dwelling, or shall have sexual intercourse under scandalous circumstances with a woman who is not his wife, or shall cohabit with her in any other place, shall be punished by prisión correccional in its minimum and medium periods. The concubine shall suffer the penalty of destierro. For this slide, we are now going to compare the elements of adultery and concubinage. For the crime of adultery, the first element is that the woman is married. The offender here, take note, is a married woman, whereas that of concubinage, the offender is a married man, such that the first element of concubinage is that the man must be married. Second element for the crime of adultery, that she has sexual intercourse with a man not her husband. What about for the crime of concubinage? The second element is that he committed any of the following acts. Letter A, keeping a mistress in the conjugal dwelling. Letter B, having sexual intercourse under scandalous circumstances with a woman who is not his wife. And letter C, cohabiting with her in any other place. So, sa second element pa lang, makikita mo agad yung difference ng adultery at saka ng concubinage. In adultery, there is only one act which would be enough to constitute the crime of adultery, and that is that the married woman has sexual intercourse with a man who is not her husband. Whereas in the crime of concubinage, there are three acts by which a married man can commit the crime of concubinage. Let's now go to the third element. That as regards the man with whom she has sexual intercourse, he must know her to be married. What about the third element in the crime of concubinage? That as regards the woman, she must know him to be married. So readily you can observe that with respect to the first and the third elements, they are practically the same. The only difference lies in the person of the offender, because in adultery, the offender is the wife or the married woman, whereas in concubinage, the offender is the husband or the married man. Let us discuss each of the elements of the crime of adultery. First element, that the woman must be married, or that the woman is married. Before proceeding, allow me at this juncture to emphasize that the essence of the crime of adultery, as well as that of concubinage, is the violation of the marital vow. Without this marital vow, no crime of adultery or concubinage can take place. That is why, in the first element, it is required that the offender must be married to the offended party. Now, in the crime of adultery, the offender is the wife. The offended party is the husband. Second point, because of the use of the phrase, even if the marriage be subsequently declared void, it is not necessary that there be a valid marriage between the offended husband and the guilty wife. Now, you might ask this question. Di ba sabi mo kanina, Fiscal, na dapat married yung guilty wife dun sa husband niya. Kasi, ang sabi mo, ang essence ng crime of adultery is the violation of the marital vow. Eh bakit ngayon? Hindi pala necessary na valid yung marriage ng dalawa. Let me discuss further. It is not necessary that there be a valid marriage between the two because for as long as there has yet been no judicial declaration of the nullity of the said marriage, then the crime of adultery can still be committed. It is enough that there was a marriage which has not yet been declared null and void. So hanggang wala pang declaration mula sa korte na void yung marriage ng wife at saka ng husband, kahit na void talaga, no, even if the marriage be subsequently declared void, for as long as there was yet no declaration of its nullity at the time the crime was committed and also at the time of the filing of the complaint, then the charge of adultery can still prosper against the accused or against the offender, who is the wife here. The judicial validity of the woman's marriage, therefore, is not material for the successful prosecution of the crime of adultery. Take note, however, that the husband, the offended party here, must still be married to the wife, the offender, at the time of the filing of the complaint. Otherwise, he no longer has the right to file the case. What's the reason here? The husband can no longer be considered the offended party. And do I have a legal basis for this? Yes. Under Article 344 of the Revised Penal Code, it is expressly stated there that only the offended spouse can file a complaint for adultery or concubinage. No other person can. Here are examples of the first element. Example number 1. X, the wife, committed adultery. Y, the husband, after learning about his wife's infidelity, filed a criminal complaint for adultery. Their marriage, however, was subsequently declared void by the court. Question: is there adultery? The answer is yes. It is not necessary that there be a valid marriage between the offended husband and the guilty wife. Article 333 clearly states that there is still adultery even if the marriage be subsequently declared void. Example number 2. X, the wife, committed adultery. Y, the husband, after learning about his wife's infidelity, filed a petition in court to have their marriage declared void. The court subsequently declared the marriage void. Question: can Y, after the marriage has been declared void, still file a criminal complaint for adultery? The answer is no more. the husband, the offended party here, must still be married to the wife, the offender, at the time of the filing of the complaint. Otherwise, the husband no longer has the right to file the case. This is so because the husband can no longer be considered the offended party. Take note that under Article 344 of the Revised Penal Code, it is only the offended spouse who can file a complaint for adultery. Let's now go to the second element, that she, referring to the married woman, has sexual intercourse with a man who is not her husband. First point, there must be actual sexual intercourse and not just mere romantic dating or petting or kissing. The second element is the operative act that consummates the crime of adultery. Without the sexual intercourse, if there be merely petting or kissing or holding hands or caressing each other, those acts will not constitute the crime of adultery. To repeat, what constitutes the crime of adultery is actual sexual intercourse by the married woman with a man who is not her husband. Second point, there is neither an attempted nor a frustrated stage here. The crime of adultery can only be punished in the consummated stage, meaning there must be proof that the wife and her paramour had actual sexual intercourse. Also take note that the crime of adultery is not a continuing crime because each act of sexual intercourse is a distinct and separate crime. Meaning to say, if the offender spouse, the married woman, has sexual intercourse with a man who is not her husband, that act of sexual intercourse constitutes one count of adultery. If she commits another act of sexual intercourse with a man who is not her husband for the second time or the third time or the fourth time, for as many times as she wants, those acts will likewise constitute separate counts of adultery. Question: must the offenders, I am referring to the guilty spouse and her paramour, be caught in the act of having sexual intercourse for purposes of proving the crime of adultery? The answer is no. Carnal knowledge may be proved by circumstantial evidence. Direct proof is not necessary. Circumstantial evidence such as will lead a reasonable man to the conclusion that sexual intercourse has taken place is enough to prove the crime. Now, you might ask, Fiscal, sabi mo, dapat merong proof of actual sexual intercourse. Di dapat meron talagang direct evidence, meron talagang proof na may nakakita sa kanila na nag-sexual intercourse. Now, let me remind you that we have to recognize the reality that in certain instances, direct evidence is not possible due to the inherent attempt of a criminal to conceal a crime. Usually, yung mga sexual intercourse, patago kung ginagawa. So, it is very hard to require the prosecution or the complainant for that matter, the offended spouse, to always secure direct evidence. That is why circumstantial evidence, as will lead a reasonable man to conclude that sexual intercourse has taken place, is enough to prove the crime of adultery. Let me give you some examples of the second element. Example number 1. X suspected his wife Y of having a romantic affair with Z. One night, While Y was sound asleep, X accessed Y's phone and found several messages in Facebook Messenger showing his wife and her paramour's declarations of love for each other. They even reminisced their previous sexual escapades and even planned to continue seeing each other at a future date. X likewise was able to obtain CCTV footages of X and her paramour going in and out of the room of a well-known motel, not just once but on several occasions. A witness likewise saw X and her paramour embracing and kissing each other at a beach resort while Y was on official travel or leave. Question: are these circumstances enough to prove sexual intercourse between the wife and her paramour? What do you think is the answer here? The answer is yes. Such evidence is already sufficient to show that X and her paramour had the opportunity to satisfy their adulterous inclination, as ruled in the case of U.S. versus Feliciano. Here is another example. X and her paramour Y lived together as husband and wife in different places, at diverse times and for certain periods, and actually were seen lying together at late hours of the night in their underwears and caressing and embracing each other. Question: are these enough to prove sexual intercourse? The answer is yes, as ruled in the case of People versus Dante. You must remember that circumstantial evidence, as was shown for both examples number 1 and 2, is sufficient for conviction if, number 1, there is more than one circumstance. Again, with respect to both examples number 1 and 2, there was more than one circumstance. And number 2, the facts from which the inferences are derived are proven. And number 3, the combination of all the circumstances is such as to produce a conviction beyond reasonable doubt. Also, the circumstantial evidence presented must constitute an unbroken chain which leads one to a fair and reasonable conclusion pointing to the accused, to the exclusion of the others as the guilty person. The circumstantial evidence must exclude the possibility that some other person has committed the crime. Again, as shown in examples number 1 and 2, the combination of all these circumstantial evidence constituted an unbroken chain that led us, you and me, both having reasonable minds, to the conclusion that no other person could be guilty of this crime but the two accused, the offender and her paramour. Third element, that as regards the man with whom she has sexual intercourse, he must know her to be married. First point, the man, I am referring to the paramour of the guilty wife, may be single here or married. If he is married, he could be also held liable for the separate crime of concubinage under Article 334 of the Revised Penal Code. We will discuss this crime of concubinage in the next few slides. Second point, there must be proof that the man, prior to the sexual intercourse, knew the woman to be married. Otherwise, the man is not liable for adultery. Meaning to say, if the man knew the woman to be married only after the sexual intercourse had taken place, then he is not liable for adultery. Let us say, if after learning that the woman is married, had sexual intercourse again with her for the second time, will he be liable for adultery? Yes. Why? Because he already knew prior to the sexual intercourse that the woman is married, and yet he continued to engage in adulterous relations with her. Now, let us say the man is not liable for adultery because he did not know the woman to be married, but he himself is married. He may be held liable for concubinage under Article 334 if he commits any of the ways of committing the crime of concubinage under the said article. That is, if he, for example, keeps the woman in the conjugal dwelling, or he had sexual intercourse with her under scandalous circumstances, or he cohabited with her in any other place. Now, the woman who is liable for adultery may also be held liable for concubinage if she knew that the man whom she had sexual intercourse with is also married. So, there could arise here a situation wherein the guilty wife will not only be liable for adultery, but she will also be held liable for concubinage if the man with whom she had sexual intercourse with is also married. And the man, the paramour, in that example, if he is also married, he will be liable not only for the crime of adultery, but he could also be held liable for the crime of concubinage if he commits any of the ways by which the crime of concubinage can be committed. Example: X, a married woman, had sexual intercourse with Y, her paramour, but Y is married to Z. X knew that Y is married. Y also knew that X is married. Now, despite being married to their respective spouses, X and Y decided to elope and cohabit in another place. Question: what is the liability of X and Y? X is liable for adultery for having sexual intercourse with a man who is not her husband. Why? X is also liable for concubinage for having cohabited with Y knowing him to be married. What about Y? What is the liability of Y? Y is liable for concubinage for cohabiting with a woman who is not his wife. He is also liable for adultery for having sexual intercourse with X, knowing her to be married. Let us now discuss each of the elements of concubinage. First element, that the man must be married. At this juncture, a question might be asked: Fiscal, if we compare the provision on adultery with the provision on concubinage, one can readily observe that in the provision on adultery, merong nakalagay doon na phrase na even if the marriage is subsequently declared void. And as you have already explained, the validity of the marriage between the guilty wife with the offended husband is not important for purposes of proving the crime of adultery. But in the crime of concubinage, there is no such phrase. The phrase, even if the marriage be subsequently declared void. Now, the next question is, dapat ba na valid talaga yung marriage with respect to the marriage between the offending husband with his offended wife in the crime or for purposes of the crime of concubinage? Or should they be accorded the same interpretation? My answer to those two questions is this: kahit walang nakalagay na phrase na even if the marriage is subsequently declared void sa provision ng concubinage, in the case of Beltran versus People, the Supreme Court had already made clear that so long as there is no such declaration, I am referring to the declaration of the nullity of the marriage, the presumption is that the marriage exists for all intents and purposes. According to the Supreme Court in that case, he who cohabits with a woman not his wife before the judicial declaration of nullity of the marriage assumes the risk of being prosecuted for the crime of concubinage. Parties to the marriage should not be permitted to judge for themselves its nullity, for the same must be submitted to the judgment of a competent court, and only when the nullity of the marriage is so declared can it be held as void. Ito ang pronouncement ng Supreme Court, which leads me to conclude that the first element in the crime of concubinage should be accorded the same interpretation as with the first element in the crime of adultery. Meaning to say, the validity of the marriage of the spouses for purposes of proving the crime of concubinage or of adultery is not important. Kahit na walang nakalagay na phrase na even if the marriage is subsequently declared void in the provision on concubinage. Example number 1. X is married to Y. X, however, cohabited with another woman. Thereafter, X filed a petition in court to have his marriage declared void. Y, in turn, filed a complaint for concubinage. X moved that the criminal proceedings against him be suspended to await the judgment in the civil case for the nullity of his marriage. Question: is X correct? The answer is no. The judicial validity of the man's marriage is not material. It is enough that there was a marriage which has not yet been declared null and void. The pendency of a civil action for nullity of marriage does not pose a prejudicial question in a criminal case for concubinage. Example number 2. X, the husband, committed concubinage. Y, the wife, after learning about her husband's infidelity, filed a petition in court to have their marriage declared void. The court accordingly declared the marriage void. Question: can Y, the wife, still file a criminal complaint for concubinage? The answer is no more. The wife, the offended party here in the crime of concubinage, must still be married to the husband, the offender, at the time of the filing of the complaint. Otherwise, the wife no longer has the right to file the case. Reason: the wife can no longer be considered the offended party. Similar to what I explained in the crime of adultery, and as supported by Article 344, only an offended spouse can file a complaint for concubinage. So, ang ibig lang sabihin ng example number 2 is that the offended spouse, the wife, in this crime of concubinage, must still be married to the offender at the time, as I said, of the filing of the complaint. Because if she is no longer married to the offending spouse when she files the complaint, then she will no longer be considered as the offended spouse under Article 344. Second element, that he committed any of the following acts. Letter A, keeping a mistress in the conjugal dwelling. Letter B, having sexual intercourse under scandalous circumstances with a woman who is not his wife. Or letter C, cohabiting with her in any other place. So the second element, as you can see, states the three different ways by which the crime of concubinage can be committed. Let us discuss each of them. First way of committing concubinage, by keeping a mistress in the conjugal dwelling. Conjugal dwelling means the home of the husband and wife, even if the wife happens to be temporarily absent. Example number 1. X and Y, husband and wife respectively, built a house which they intended to use as their dwelling place. Y wasn't able to live in the said house as she had to go abroad to work as a domestic helper. X later used it with his mistress instead, meaning X cohabited, no, or lived in that conjugal dwelling not with his wife but with his mistress. The concubine, take note, must live in the conjugal dwelling even for brief periods of time and not where she occasionally comes for a sexual intercourse or to spend the night therein. Example number 2. X and Y, husband and wife respectively, separated. Y left the conjugal dwelling. X thereafter brought in his mistress and lived therein like husband and wife for a few months. Here, X is liable for concubinage because he is deemed to have kept his mistress in the conjugal dwelling. Example number 3. The spouses X and Y have a house helper named Z. X, the husband, and Z, the house helper, got physically attracted to each other and engaged in clandestine trysts inside the conjugal dwelling whenever the wife was not around. Z, though, continued working as a helper inside the conjugal dwelling, doing the same routine every day, as if she were really a house helper. Question: is X liable for concubinage? The answer is no, because it would appear here that X never considered Z as a concubine. In order to be liable for concubinage, it is necessary that Z is taken by X into the conjugal dwelling as his concubine. Second way of committing concubinage, by having sexual intercourse under scandalous circumstances. First point, it is only when the mistress is kept elsewhere that the phrase scandalous circumstances is an element of the crime. Second point, ano ba itong scandal? A scandal is an action or an event regarded as morally or legally wrong and causing general public outrage. What are regarded as scandalous circumstances that would constitute the crime of concubinage? The public or open flaunting of the illicit relationship so that the public is scandalized and shocked, or that the conduct gives rise to general protest. The offender in this second way of committing concubinage must be so imprudent and wanton as to offend the sense of morality and decency of the people who know them. Another question, should there be proof of actual sexual intercourse under scandalous circumstances? The answer is no. Proof of sex is not necessary but may be inferred. For example, X, a married man, is often seen with his mistress in social and public gatherings, introducing or treating her as though she were the wife. That is an example of a scandalous circumstance. Hindi kailangang merong pruweba talaga that there was sexual intercourse between the guilty husband and his mistress, it is enough that both of them are seen together in public gatherings, which causes moral outrage on the people who know their activities or who know their persons. It must be noted, however, that public reaction is the gauge of the scandal. If there is no testimony of people whose moral senses were outraged by the illicit relationship, then there is no scandal. Meaning to say, it cannot be said that the sexual intercourse was committed under scandalous circumstances. Example number 1. X, the wife, caught her husband Y in the act of having sexual intercourse with another woman inside a motel. No one other than the wife saw the incident. Is the husband guilty of concubinage? The answer is no. The sexual intercourse was not under scandalous circumstances. Example number 2. X, the wife, suspected her husband Y of having a mistress. X then hired a detective to spy on her husband. True enough, the detective was able to take several pictures of Y and his mistress going in and out of the latter's apartment. Question: is this enough to prove concubinage by means of sexual intercourse under scandalous circumstances? The answer is no. There must be proof that the moral senses of people living in that vicinity were outraged by the suspicious activity. So, if you look closely at examples number 1 and 2, mere sexual intercourse by the married man with a woman who is not his wife does not per se constitute the crime of concubinage. It will not make him criminally liable for concubinage. It is different with adultery, because in adultery, the mere sexual intercourse by the wife with a man who is not her husband consummates the crime of adultery, or is enough to constitute the crime of adultery, but not with the crime of concubinage. Please take note of that. Example number 3. X, the offending husband, and his mistress are openly going out in places where the two are total strangers. Here, there is no concubinage because there is no possibility of moral outrage from people who know of the illicit relationship. Not unless magpo-post sila ng mga pictures sa Facebook showing their intimacy together. That will be a different story. But kung nagpunta lang sila sa lugar na walang nakakakilala sa kanila, then there would be no opportunity of immoral outrage because people there do not know them. Third way of committing concubinage: by cohabiting with the woman in any other place. To cohabit means to dwell together in the manner of husband and wife for some period of time. Thus, in a case, the Supreme Court ruled that cohabitation can be a week, a month, a year, or longer. Example number 1. X, the offending husband, abandoned his wife in Manila and went to Cebu together with his mistress. They lived together as husband and wife in an apartment. The unsuspecting neighbors thought that they were really a legitimate couple. Question: is there concubinage? Yes. This time, mere cohabitation is enough. Proof of actual sexual intercourse under scandalous circumstances is not necessary insofar as the third way of committing the crime of concubinage is concerned. Example number 2. The husband provided his mistress her own house or apartment, but does not live with her, although he regularly visits her in that place to engage in sexual intercourse with her. Question: is there concubinage? The answer is no. There must be proof of cohabitation or that they had sexual intercourse under scandalous circumstances. Example number 3. In the criminal case for concubinage, the prosecution was able to prove that X, the husband, is married and that he is the father of the child of his mistress. Question: is X guilty of concubinage? The answer is no. Having a child by another woman by itself is not sufficient. There must be proof of the commission of any of the 3 ways of committing concubinage under Article 334 of the Revised Penal Code as amended. Also take note that the prepositional phrase "in any other place" means that the cohabitation must be done in a place outside of the conjugal dwelling, because if the offending husband cohabits with his mistress in the conjugal dwelling, then it is not the 3rd way of committing the crime of concubinage that is or that has taken place, but the 1st way of committing the crime of concubinage. Here is now a summary of the distinctions, major distinctions between adultery and concubinage. In the crime of adultery, mere sexual intercourse with a man, not her husband, is enough to constitute the crime. Whereas in the crime of concubinage, mere sexual intercourse with a woman who is not his wife will not make the husband criminally liable for concubinage, because concubinage can only be committed in any of these 3 ways. Number 1, keeping a mistress in the conjugal dwelling. Number 2, having sexual intercourse under scandalous circumstances with a woman who is not his wife. And number 3, cohabiting with the said woman in any other place. Second major distinction. In adultery, each sexual intercourse is a separate and distinct crime. Why? Because it is not a continuing crime. Whereas in the crime of concubinage, no matter how many times the illicit couple had sexual intercourse, there is only one crime to be charged. Why? Because it is a continuing crime. Third major distinction. In adultery, the penalty is higher. That is, for both the guilty wife and her paramour, the penalty is prison correctional medium and maximum. Take note that when the guilty wife, however, committed the offense while being abandoned without justification by the offended spouse, the penalty of arresto mayor maximum to prison correctional minimum shall be imposed instead. Meaning, if this is the situation obtaining, it will be considered as a mitigating circumstance which will entitle the guilty wife to a penalty 1 degree lower than the imposable penalty. Whereas in the crime of concubinage, the offender shall be punished by prison correctional minimum and medium, which is lesser or lower than the imposable penalty in adultery, while the penalty for the concubine will only be the penalty of destierro. Now, why is it that the penalty is higher in the crime of adultery than in the crime of concubinage? The reason is because adultery makes possible the introduction of another man's blood into the family, so that the offended husband may have another man's son bearing his surname and receiving support from him. This is the evil sought to be avoided by imposing a higher penalty for the crime of adultery than for the crime of concubinage. There is no possibility that an offspring will be entered or will be introduced into the family of the offending husband. Why? Because it is not the offending husband who will get pregnant. Whereas in the crime of adultery, there is a great possibility that an offspring will be introduced into the family without the offended husband knowing that the father of the child is not him, but the woman, or rather, but the man with whom his wife had sexual intercourse with. What are the defenses in the crime of adultery and concubinage? For both adultery and concubinage, we have pardon by the offended spouse. The pardon, however, must come before the institution of the criminal action, meaning before the case is filed in court. Also, both the offenders must be pardoned by the offended spouse. The offended spouse cannot just pardon his wife or her husband and then prosecute the paramour or the mistress. Also, the pardon here need not be expressed because the act of having sexual intercourse with the offending spouse subsequent to the adulterous conduct constitutes implied pardon. For example, the husband, after discovering that his wife had an affair with another man, made love to her. This is a case of implied pardon, meaning to say the husband can no longer file a case for adultery against his wife. Example number 2. The wife, after having been pardoned by her husband, continued her affair with another man. Can the offended husband still file a case of adultery against his wife? The answer is yes, because the pardon here refers to previous and not to subsequent adulterous acts. Please remember what I told you in the previous slide, that the crime of adultery is not a continuing crime. Each act of sexual intercourse is a distinct and separate crime, such that the pardon made for that particular sexual intercourse is only for that particular sexual intercourse. If the offending wife or the guilty wife commits another act of sexual intercourse with a man who is not her husband for the second time, then the offended husband can prosecute or file a case of adultery against his erring or offending wife. Example number 3. The wife, despite knowing that her husband had committed any of the 3 ways of committing concubinage, acted as if nothing was wrong in their marriage, or did nothing to assert her rights as a wife. She could be deemed to have impliedly pardoned her husband or the offending spouse. Example number 4. The wife forgave her husband for cohabiting with his mistress. She forgave her husband based upon the belief that her husband had genuinely repented. The husband, however, left again the conjugal dwelling and cohabited with his mistress. Here, there was merely a condonation, not a pardon, which means that the wife can still institute a complaint for concubinage against her husband. Condonation is akin to a conditional pardon. It is a pardon wherein there are conditions attached. The wife forgave her husband on the belief that her husband had genuinely repented. That is condonation, not pardon. And in such a case, as shown in example number 4, the wife may institute or file a complaint for concubinage against the husband. Example number 5. X, the offended wife, delayed the filing of the case against her husband and his mistress because she wanted to make sure she had enough evidence to secure their conviction. Here, there is neither implied consent nor implied pardon. The delay was reasonable under the circumstances. We also have consent by the offended spouse. So, again, what are the available defenses that the offending spouse can invoke to defeat a prosecution for either adultery or concubinage? Pardon and consent. Pardon by the offended spouse or consent by the offended spouse. Now, with respect to consent, the consent here can be expressed as when the offended spouse executed an agreement with the offending spouse that he or she is free to engage in an illicit affair with another man or woman, as the case may be. Or the consent here can be implied as when the husband himself delivered his wife to another man in order to be prostituted. Now, you must remember that the pardon comes after the commission of the adulterous act, whereas consent comes before the commission of the adulterous act. Question: what can mitigate the liability of the offender in adultery and concubinage? We have to make a distinction because in adultery, if the wife committed the crime while being abandoned without justification by the husband, the penalty next lower in degree shall be imposed. This is based on the third paragraph of Article 333 itself. Now, in the case of People versus Alberto, while the husband did not abandon the wife, because what happened in this case was the husband just disappeared and the wife believed in good faith that her husband had already died at sea, she found herself in the predicament of committing adultery out of sheer economic necessity for her 3 children. Now, unfortunately, her husband reappeared and her husband filed a case of adultery against her. Now, the court ruled that yes, while she may be liable for adultery, her criminal liability should be mitigated because first, she just believed in good faith, meaning she had no criminal intent to commit the act of adultery because she really thought that her husband had already died. Now, I would even venture to state that if she had no criminal intent to commit the crime of adultery, then all the more she should have been acquitted. She should not be held liable for adultery because in the crime of adultery, good faith is a defense. In the crime of concubinage, however, there is no such counterpart provision similar to the third paragraph of Article 333 on adultery. Meaning to say, there is no room for mitigation of the criminal liability of the offender in the crime of concubinage. Last question. Who can file a complaint for adultery or concubinage? Only the offended spouse. Now, if the offended spouse doesn't want to, for whatever reason, No other person can file such a complaint. In crimes against chastity, the law recognizes the choice of the offended spouse, who might prefer to suffer the outrage in silence rather than go through with the scandal of a public trial. The offended spouse, if he or she decides to file a complaint, must include both the offending spouse and his or her mistress or paramour. The offended spouse cannot choose to forgive his or her spouse and file a case only against the mistress or the paramour. She should or he should pardon both the offenders. And finally, the offended spouse cannot also file a complaint if he or she has already pardoned the offenders or consented to their adulterous acts, as what I have already explained in the previous slides.